As a business, why is it important that we have an interview process?
It's vitally important to ensure that as a business, we have a process and approach that's effective. We're asking the sorts of questions that help us to identify people with not only the right experience and skills, but also individuals that have the right behaviours and mindsets, ones which are aligned to our competencies and values. If we get it right, then ultimately we recruit the right person first time, and this has all sorts of benefits for the business, including a good cultural fit and savings associated with recruitment. It's equally important that our approach ensures we're fair and consistent both from an employee perspective but also from a legal perspective. We should avoid making decisions that are potentially discriminative. Decisions that discriminate are often evidenced by the types of questions we ask.
What are some of the legal considerations when recruiting?
There's quite a lot of things to consider from an employment law perspective, but the main requirements for recruitment and selection are driven by the Equality Act, which came into force in 2010. This Act simplifies and brings together a number of different anti-discrimination legislation into a single act. The Equality Act prohibits discrimination in respect of 9 protected characteristics, which means, in recruitment and selection terms, it's against the law for us to decline an individual for a role on grounds of their age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex or sexual orientation.
So it's as simple as that then? We can't refuse a person a role simply because they're a certain age?
Well, it's not quite as simple as that. You need to consider the requirements before the interview itself. But from an interview perspective, you shouldn't need to ask questions relating to any of the protected characteristics, as they have absolutely no relevance. And if you do ask a question and the individual is not successful, just simply asking that question can leave us at risk of a claim. But as I say, it probably starts before the interview, when you're considering and developing the requirements of the role, advertising the role and screening applicants.
Well, that does sound like a bit of a minefield. I mean, how do we protect ourselves?
The thing is that it can be justified, and the onus is on the employer to show that what you've done or intended to do is objectively justified. We don't expect our recruiting managers to be employment law experts. In all recruitment situations, HR should be involved in the role profiling and advertising, and an appropriate trained person should be involved in the interviewing to ensure that we are acting legally.
Okay then, so what happens if we do find ourselves at a tribunal?
If a tribunal finds a complaint for discrimination well-founded, it will then proceed to consider what's sometimes called the issue of remedy. Compensation will be awarded where a tribunal feels it is just and equitable to do so. There's no upper limit on the amount of compensation that an employment tribunal can award in respect of a claim for discrimination. The law recognises 2 types of discrimination: direct discrimination, treating somebody less favourably because of one or more of the 9 characteristics. So for example, not employing a woman because of concerns that she might want to start a family. Not considering a disabled person without looking at whether they meet the selection criteria and whether any reasonable adjustments can be made. Not employing somebody because he is believed to be homosexual. And not considering a person for a job because they care for a disabled child. The other type of discrimination that the law recognises is indirect discrimination, having a criteria that puts a person with one or more of the protected characteristics at a disadvantage compared to others. Indirect discrimination is the most common in recruitment. Typical cases involve criteria required for a role which are not necessary, yet certain categories of people are less likely to meet the criteria. For example, specifying applicants should be clean-shaven may disadvantage some religious groups. Using assessment tests measuring abilities not required by the job but which could discriminate against groups of people. For example, reasoning ability tests for unskilled manual jobs which could discriminate against those without English as a first language. Using height, weight or strength requirements that are not related to the ability to perform the role are likely to discriminate against women. Asking for a specific number of years' experience that may rule out younger candidates with the skills required for the job but have not had the opportunity to demonstrate them over an extended period.
Okay, and do we often find ourselves in a tribunal situation?
Actually, it's very rare for us, but equally, it's easily done. The basic principle has always been that once an employer has established some initial evidence which suggests that, in the absence of adequate explanation, there could have been discrimination, the employer has to prove that they've not discriminated. So really, the key thing here is to be really careful to keep adequate records of your rationale and decision making.